Thanks, Robert, and hello, everyone. Let me just get my presentation up there. Okay, so as was mentioned, we have a lot to cover. This is normally like a 90-minute presentation. So there's going to be a couple areas where that you're going to see on the slides, and I'm going to kind of skim over, but I'm going to tell you where to go to get more information on those. Um, a little bit about TISLA. We are a nonprofit organization. We serve at the national level. And the reason that TISLA was founded, our reason for being, is to provide free student loan advice to all consumers. So, excuse me, anyone can access our website. We don't require registration, there's no ads. And our website is freestudentloanadvice.org. And then if people have questions, we'll answer them for free. We answer the vast majority of the questions within a business day. We do it via email only. We think that's more effective. And also, we're tiny. But you can just use the email address that's in our contact us page, and we're happy to answer your specific questions about your student loans, maybe even help you with some disputes. Little bit more housekeeping on my end. As Robert mentioned, and I'm only repeating it because this tends to be the most repeated question on any webinar I've ever been on. Yes, this is being recorded, and Robert's fine organization will make sure you have access to that recording. Yes, we take questions. Please use the Q&A panel to do that. I will ask you to hold off for a minute though, because if I'm doing my job right, I'm going to answer your questions as part of my soliloquy, so to speak. So hold off on your questions unless and until I cover the topic that your question is specifically about and see if I answer it along the way. Now, let's talk a little bit more about questions. I only have one superpower. That superpower is student loans. So we can only answer questions about student loans. We can't give you legal advice. We can't give you tax advice, financial advice. You do not want me to give you car repair advice or relationship advice for that matter. So student loans, keep it to the student loans thing. And as I mentioned, so listen, this is being recorded and it's public. You don't want your business out there, most likely to the public. So if your question's really detailed and personal, maybe don't put it in the Q&A. Maybe utilize that free resource over here at TISLA and email your question to us. So we're going to cover the basics of PSLF, how it works, what the eligibility is. Then we're going to talk about the nonsense that's going on right now with the SAVE plan and a concept called buyback. And then there was recently, over the summer, there was a negotiated rulemaking, which is how the Department of Education changes federal regulations around student loan and other topics. Spoiler alert, I was one of the negotiators there, and we're going to talk about what happened with NEGREG and what still has to happen with that NEGREG and what you should be worried about and what you should maybe not be as worried about. All right. What is PSLF? So Public Service Loan Forgiveness is a program that was written into federal law under Bush II back in 2007. If you go back and read the congressional testimony around when PSLF was written into law, you'll see that the intent of PSLF was to provide an incentive for people to go into areas of public service and stay in those areas of public service. So one of the, examples that they talk about a lot in those in that public testimony are areas such as teaching, social work, public defenders. What all those careers have in common is that you almost always have to get beyond an undergraduate degree to practice in those fields. And you have to get a graduate or professional degree. And that's where people tend to really rack up the debt. The other thing those careers tend to have in common is they tend not to pay very well. So what Congress was hearing from their constituents was like, listen, I have a passion to do this, but I literally can't afford to do it because of the student loan debt I had to take on to do the thing. I need to go into the private sector to afford my student loan debt. So that's why they created PSLF. Now, to date, excuse me, over 1 million borrowers have received forgiveness on the remaining balance, principal and interest, of their loans as a result of fulfilling the requirements for PSLF. The average amount that people get forgiven is right around $70,000 per borrower. Now, as you're going to see throughout this presentation, when it comes to student loans, there's almost always a short answer and a long answer. So here's the short answer for what you have to do to qualify for PSLF. You have to work at least 30 hours a week for an eligible employer while making the equivalent of 120 qualifying monthly student loan payments on a direct loan from the U.S. Department of Education. So the key here is that you have to hit all three of these check boxes at the same time in any given month for that month to count towards the 120. So, and I say this on almost every PSLF presentation I give. If you only remember one slide, this is a slide I want you to remember because you're going to be able to answer 80% of any question you'll ever have about PSLF. So again, in order for a month to count, all three of these checks have to be checked. You have to be working the 30 hours a week while making a payment on an eligible plan on an eligible loan. If even one of these check boxes is missing, that month is almost certainly not going to count for PSLF. Now, with all that said, let's define all the eligibles that I sort of threw out there in this particular slide. So the easy one is what's an eligible student loan. Again, we have a short answer and a long answer. The short answer is any federal direct loan is considered potentially eligible for PSLF. Now, that can be a subsidized Stafford loan, an unsubsidized Stafford loan, a Parent Plus loan, a Graduate Plus loan, or a direct consolidation loan. It doesn't matter when the loan was made. They made the very first federal direct loan back in 1994. They're still making them today. They're going to be making them tomorrow. So whether you have a vintage 1994 direct loan or a bright, shiny new direct loan, they're both equally potentially eligible for public service loan forgiveness. Now, if you have direct loans that started repayment at different times and you want to consolidate them. Now, consolidation isn't necessarily a good idea for a lot of people these days. It used to be a very good idea for most people back in the day, but that's not necessarily the case anymore. But one question that pops up a lot is if you have PSLF credits on some loans and a different amount of PSLF credit on other loans, if you consolidate, it used to reset your count to zero. That's not the case anymore. If you consolidate loans now that have existing PSLF counts, the consolidation will end up with a weighted average of the PSLF credits on the underlying loans. So let's say you had 50 grand of loans with 100 PSLF counts and 50 grand of loans with 0 PSLF counts because you just took them out and you consolidated them together, you'd end up with a $100,000 consolidation loan with 25 PSLF counts. Now, there are other federal loans that aren't eligible for PSLF in and of themselves, but if you consolidate them, they become eligible for PSLF. Now, remember, in order to get credit for PSLF, you have to check all three of those boxes, and one of those boxes is having an eligible loan. So by consolidating one of the loans you see in front of you, you will be starting from scratch. Unless you consolidated that loan prior to June of 2024. The Biden administration had a waiver in place for a time, but that waiver is over. So that includes loans that we call FFEL loans, which are Federal Family Education Loan Program loans, federal nursing loans, Perkins loans, the old HEAL program, which was for medical students, nurse faculty loans, loans for disadvantaged students, any of the loans you see in front of you. Again, they're not eligible for PSLF in and of themselves, but if you consolidate them, into the direct loan program, which you can do at studentaid.gov, they then become eligible for PSLF going forward. Where people get a little confused is with the FFEL program. The FFEL program was exactly the same as the direct loan program, except where they were different. If you took loans out prior to July 1st, 2010, and it's either a Stafford loan, a Graduate or Parent Plus loan, or a consolidation loan, It could be either a FEL or a direct loan. So it's really, really important that you know which one it is. And the way to tell is there's a couple ways. Log on to your loan servicer or studentaid.gov, and in front of the loan, it should say either FFEL or direct loan, or you could just call your servicer and ask them. If the loan says Stafford loan or Grad Plus or consolidation, and it was dispersed on or after July 1st, 2010, you know it's a direct loan because they stopped making FEL loans on or after that date. Now, if you have a private loan, even if it's a private loan that used to be a federal loan and for whatever reason you decided to refinance it to the private loan program, which I strongly urge everybody to never ever do that. Um, not just for PSLF reasons, but federal loans have a lot of unique safety nets that private loans just don't have. But private loans, loans that you borrow directly from your school, where the school is the lender, state loans. For example, here in Massachusetts, we have the Mass No Interest Loan. That would be considered a state loan. Loans that aren't in your name, or other forms of credit you may have used to pay for college. Those are not eligible for PSLF and they can never be made eligible for PSLF. And if for some reason you did refinance a federal loan into the private loan program, I'm afraid there's no take backsies on that. So that's forever a private loan and you forever lost your eligibility for PSLF, unfortunately. So look at that. We're already a third of the way through all of our eligibles. We know what an eligible loan is for PSLF purposes, and that is any federal direct loan, regardless of when that loan was made. Now let's define what eligible employment is. Now, this is where a lot of the myths and misconceptions I find are around PSLF. Number one, it doesn't matter what you do for a living at all. What matters is who you work for. Now, in order to be considered working eligible PSLF employment, you do have to be working at least 30 hours a week for either a government employer, and that can be federal, state, local, tribal. It can be full-time in the military, the Peace Corps, AmeriCorps, or working 30 hours a week for any 501c3 nonprofit. If you work for either a government employer or a 501c3 and you're a direct employee of one of those entities, you are working PSLF eligible employment. Full stop. Now, where there can be a few more hoops to jump through is if you work for a nonprofit that's not a 501c3. Now, some of those do qualify, but only if their primary reason for being is one of the items on the list you see in front of you. This is a finite list. So that includes public education, public interest law, public safety, emergency management. Now, let me give you an example. I'm a big fan of examples for clarity reasons of what I mean by primary reason for being. So let's say you work for an animal shelter. And the reason that animal shelter was created was to rescue animals. It is a nonprofit, but it's not a 501c3. Well, it just so happens that that animal shelter offers free classes to the public on things like animal pet first aid or how to do the Heimlich maneuver on your dog or how to train your cat to use the potty instead of the litter box or how to deal with aggressive animals. I think anybody in their right mind would argue that especially if the classes are free to the public, that's public education. Um, but that's not the entity's primary reason for being. Their primary reason for being is to rescue animals. So in that scenario, that employer would not be considered eligible for PSLF. Now, let me give you another example. Let's say that you are working at a public school. Let's say you work for the Los Angeles public school system. I think what I tend to find in scenarios like that is if you're a teacher in a public school system and you have student loans, you're probably aware of PSLF and that you're potentially eligible. But everybody else who works for the LA public school system is equally potentially eligible for PSLF, whether they're the custodian or the administrative assistant or the principal or the art teacher or the groundskeeper or the security officer. If they're a direct employee of the LA public school system, then they are eligible for PSLF. So again, what matters is who you work for, not what you do for a living. You do have to be working eligible employment at the time you make every single one of those 120 required payments for PSLF. And you also have to be working eligible employment at the time you apply for PSLF. Now, it used to be you also had to be working eligible employment at the time they approved your forgiveness. That's no longer the case. So if you're looking to retire or leave your job, if you're certain that you've hit the milestone of the 120 qualifying payments and you've submitted your forgiveness application, if you want to quit or retire, you can do that. If you can wait a couple months until they actually approve your forgiveness just to be on the safe side, it's probably not a bad idea, but you certainly are not required to. One last thing about eligible employers. If it's a labor union, a partisan political organization, a for-profit organization, or a not-for-profit that's not a 501c3 and whose primary reason for being is not on that finite list on the slide I showed you before, I'm afraid you can never be eligible for PSLF. Now, there is one exception to that, and California was one of the states that this exception was created for, as a matter of fact. If you work for an entity, most often a for-profit, but you do all your actual work for an eligible nonprofit entity, and the reason it's set up that way is because state law specifically prohibits the eligible entity from hiring you directly, that will now count for PSLF. Now, let me give you an example. Apparently in California and in Texas, state law specifically prohibits the nonprofit arm of a hospital from directly hiring physicians. So what the hospitals do is they have a nonprofit arm and they have a for-profit arm. And the for-profit arm hires the doctors, but the doctors many of them do all their work directly for the eligible nonprofit arm of the hospital. In that scenario, it would count for PSLF. Now, here in Massachusetts, no such law exists, but it is still very common for our hospitals to have a nonprofit arm and a for-profit arm. In that scenario, if the borrower was hired and is considered the employee of the for-profit arm, even if they still do all their work for the nonprofit arm, they would not qualify because there's nothing in our state laws that prohibits the nonprofit arm from hiring the doctor directly. So in that case, it's a matter of contract negotiation. Make sure it's the nonprofit arm that hires you. If you're a 1099 contractor, we're starting to get this question a lot. It likely is not going to count. You have to, again, unless there's something very specific in state law that would prohibit them from hiring you directly. Couple more things about employment. As I mentioned, you do have to be working eligible employment at the time you make all your eligible payments and at the time you apply for forgiveness. You do not need to be working for a single eligible employer. You could be working 15 hours a week for 2 eligible employers as long as it was at the same time. Periods of FMLA or vacation, that's fine. They still count towards PSLF. Teachers who are under an annual contract, as long as you were working at least 30 hours a week for 8 months of those contracts, in other words, they don't mind that you didn't work during the summer, they'll count the summer as long as you were under an annual contract that covers that summer period. It's the actual borrower of the loan who has to be working the eligible employment. We get a lot of questions from families where there's Parent Plus loans. And while Parent Plus loans are eligible for PSLF, a lot of times there's a sort of a handshake agreement within the family that the student who benefited from the loan is the one making the payments. That's fine. they'll take money from whomever and it'll count. But it's the parent borrower who has to be working the eligible employment in order to get credit for PSLF. And before you ask, for those of you that already started typing this question, unfortunately, there's no way to change who the actual borrower is on the loan. So for parents that are going to be borrowing in the future, one thing to consider is that if you're thinking about PSLF, you want to probably make sure that the parent borrower who's working PSLF eligible employment, and who likely will continue to work PSLF eligible employment for the foreseeable future, is the one who's going to be borrowing the loans. All right, so we've got two of our eligibles defined. We know what an eligible loan is. An eligible loan is any direct loan. We know what eligible employment is. Eligible employment is working at least 30 hours a week for any government employer, any 501c3 nonprofit, and in some cases, a nonprofit that's not a 501c3, as long as their primary reason for being is one of the items on that list that I showed you on the prior slide. So before we define our third eligible, I'm going to take a breath and I'm going to take a sip of water. I'm going to check in with Addison, another TISLA employee, to see if he's gotten any questions in the Q&A about what we've covered so far that might be good for the whole group to hear, or what might need some additional clarity.
Hi, thanks, Betsy. We have had a number of questions regarding working for for-profits as contractors for eligible employers.
Yeah, I just want to reiterate that unless state law would specifically prohibit them from hiring you directly, which is very rare, it will not count for PSLF. So, you may want to see if they will consider hiring you directly. Let's talk about proving your eligible employment real quick before I get into talking about what an eligible payment actually is. So listen, you're not required to submit proof of your eligible employment until you think you've hit the 120. I am here to tell you that that is a terrible, terrible strategy. If that's how you're doing it, then I suspect your middle name is Danger. I strongly recommend that people submit proof of their eligible employment on an annual basis. And the way you do that is at studentaid.gov through something called the PSLF Help Tool. And maybe someone will put a link to that up in the chat for you. Now, you can't certify employment that you haven't worked yet. So you're always certifying employment retroactively. So if you were to certify your employment today, you could only certify your employment up to today. Even if you were planning on continuing to work eligible employment for the foreseeable future, none of us can see the future. You might win the lottery tonight. I hope you do. You might get fired tomorrow. I hope you don't. But the reason that we strongly, strongly urge people to file proof of employment on an annual basis is a couple reasons. First of all, the best way to make sure that you're doing everything right is to file your proof of employment. Because when you do, they're going to send you back a letter, and up on your PSLF dashboard at studentaid.gov, they're going to show you which months count and which months don't, and hopefully the reason that those months don't count. So if you're perhaps not on an eligible plan or don't have an eligible loan, better to find out now than 10 years down the road when you think you're about to actually get forgiveness, and turns out none of the years have counted. And I have seen that happen to people. The other reason is you want to make sure you can actually get your employment certified. Employers close, employers merge, employers get rid of records. It used to be that people kept records for forever. But now, if your organization has a halfway decent legal and information security areas, they're advising the employer to get rid of records as soon as it makes sense to do so. I have seen, unfortunately, many, many borrowers that have not been able to get prior employment approved for one of the reasons that I just gave you. Now, sometimes you can submit W-2s in those cases, but W-2s are not a slam dunk. So a lot of times W-2s don't have enough data on them to allow the PSLF vendor to approve that time for you. Now, with that said, you can go back. So nothing prior to October of 07 counts because PSLF didn't exist before then anyway. But you can go back as far back as October of 2007 at any point. There's no sort of stale date to when you submit the certification, but it gets more, the longer you wait to submit proof of employment after you've worked it, the more fraught with peril getting that employment approved tends to be. Okay, let's talk about what an eligible plan is, an eligible payment is. An eligible payment is a payment that's made on an eligible loan while working eligible employment when a loan is not in default under an eligible plan. Now, an eligible plan, so in the federal student loan program, there's a lot of different repayment options available to existing borrowers. Now, there's not going to be anywhere near as many plans for new borrowers on or after July 1st, 2026. So anybody who borrows on or after July 1st, 2026 is only going to have access to two plans, the standard repayment plan and what's called the RAP plan. But anybody with loans today who doesn't borrow or consolidate on or after July 1st, 2026 potentially has access to some or all of the plans that you see in front of you. Now, the plans in orange, which is the graduated repayment plan, the extended repayment plan, the extended graduated repayment plan, and the standard consolidation plan tend not to count for PSLF. The 10-year standard plan, which is the plan you get when you first go into repayment if you don't actively choose another plan, that does count for PSLF. Also, the plans in orange, if it just so happens, and this is rare but not impossible, that the amount of your payment under one of the plans in orange is equal to or more than what you would have paid under the 10-year plan, then they will count that towards PSLF as well. Any plan that's based on your income, so whether it be what we called old IBR, which anybody with a direct loan or a FEL loan could qualify for. Parent Plus loans have to jump through some hoops to qualify for IBR, but they could potentially qualify for it as well. New IBR, which is only for borrowers who never borrowed prior to July 1st, 2014. The Pay As You Earn program. Now, that program is for borrowers who didn't borrow prior to October of 07. You could still get on that plan today, but if you do, you're going to have to find a new plan by July of 2028 because Congress is getting rid of it as of July of 2028. But even though they're going to get rid of it, any payments you made on that plan or any of these plans will still count towards PSLF. The SAVE plan, if you happen to be one of the few people that actually made a payment on the SAVE plan before the litigation caused you to go into forbearance, those will count towards PSLF, but the SAVE forbearance period does not count towards PSLF. And I'm going to stop your typing fingers again real quick. I'm sure there's a ton of questions about the SAVE forbearance. I am going to address them in a few minutes. Income contingent repayment. That plan does count for PSLF. You can get on it now, but that's something else that's sunsetting in July of 2028. So you can get on it now, but expect to have to switch by July of 2028. And finally, there's a new plan that's not available now, but will be by July 1st, 2026, and it's called the Repayment Assistance Plan, or the RAP. I have some details about how that plan is going to work, but we're waiting for some additional Department of Ed guidance on some of the other details around the RAP plan. Now, as I mentioned, if you borrow a new loan or consolidate on or after July 1st, 2026, you're going to lose access to everything you see in front of you, even on your existing loans, except for the RAP plan and what's considered the new standard plan. Now, the new standard plan, the way it's going to work is that if you owe $25,000 or less altogether of all your federal loans, you'll be given a 10-year term, and that will count for PSLF. If you owe between 25 and 50 grand, they're going to give you a 15-year term. If you owe between 50 and 100, they're going to give you a 20-year term. If you owe more than 100, your term's going to be 25 years. And unless your term's 10 years on the standard plan, it will not count for PSLF. The RAP plan. The way the RAP plan is going to work is if your adjusted gross income is less than 10 grand, your annual payment amount will be $120, which means your monthly payment amount will be $10 a month. Now, the existing income-driven plans, if your income is really low, you can have a $0 payment, and that $0 payment will count towards PSLF, assuming you're not in forbearance or deferment, for example. There is no $0 payment under the RAP plan. So the lowest your payment can be under the RAP is that $10. If your adjusted gross income is between 10 and 20 grand, that your annual payment is going to be 1% of your AGI, and then they'll divide that by 12, and that'll be your monthly payment amount. And as you'll see from the chart, it goes up to a maximum of an AGI of $100,000 or more, in which case they're using 10% of your AGI and dividing that by 12. Now, if you have dependent children, they're going to subtract $50 from that payment. We think they're subtracting $50 a month per child, but there's a little bit of gray in the way the budget reconciliation bill was written around this. So next week, we're starting a negotiated rulemaking process where we're going to figure out how the Department of Education is defining that $50 credit per child, if it's going to be per month or per year. For all the income-driven plans, including the RAP, if you're married and you file your taxes jointly, they are going to use not only your income in the calculation, but your spouse's income in the calculation. If you file your taxes separately, they will only use your income. Now, if you live in a community property state, and you file your taxes separately, your AGI is going to be half of the total income between you and your spouse. What else is there about income? We have a lot of, as I mentioned, we have a lot of open questions about the RAP plan that we won't have answers to for a couple months. A couple more things about eligible payments. They have to be made on or after October of 07 to count. You don't have to make consecutive PSLF payments. You could work for an eligible employer or say be on an eligible plan for 4 years. Say you have 48 PSLF payments under your belt, and then maybe you become a stay-at-home parent, or you go into the private sector, or for whatever reason you get off an eligible plan for a year and a half. That's fine. Once you go back to meeting all those 3 of those check boxes, those 48 payments you've already accrued will already be waiting for you. The only way your PSLF count is ever going to change or reduce is, as I mentioned, if you consolidate and your consolidation loan is made up of underlying loans that have had different PSLF counts, in which case they do that weighted average for the consolidation loan. Now, it used to be the payment had to be made on time to count for PSLF. Right now, right this second, the payment can be late and still count for PSLF as long as you weren't in default. Now, I have a feeling, and don't quote me on this, this is pure speculation on my part. It may come to pass that they're going to make the rule be that once again, the payments have to be on time going forward to count for PSLF. Now, in the past, on time was defined as within 15 days of the due date. But again, right this second, the payment does not have to be on time to be considered an eligible payment for PSLF. Now, during COVID, you weren't required to make payments for almost 3.5 years. If you were working eligible employment at the time and you say weren't in school or weren't in default, that period of time does count for PSLF, despite the fact that you weren't required to make payments. And if you're pursuing PSLF, I hope you didn't make payments during that time. You can make a lump sum payment and have it count to PSLF, but it's not going to get you PSLF any quicker. Because remember, you can't certify the employment until you've actually worked it. And the lump sum payment provision is limited. So let's say your payment's $100 a month, and in January you make a $1,200 payment. That will count through December. You can't make a lump sum payment that will count longer than 12 months. And they'll also not count the lump sum payment beyond when you're due to recertify your income-driven plan. Income-driven plans usually are required to be, you have to recertify your income on an annual basis. A lot of people haven't had to do it in a while because of COVID and the save litigation and all that stuff. But going forward, you're all gonna have to recertify your income annually again. So going back to my example, your payment's $100 a month. In January, you make a $1,200 payment. That'll be good to the lesser of December. Or let's say you're due to recertify your income-driven plan in June. They'll count it through June, but then once you recertify your income, as you're required to do, come July, you'll be required to make payments again. The only good reason to pay yourself ahead like that and do a lump sum is if someone else is paying it. Some people are lucky enough to work for employers that will reimburse or do some sort of student loan repayment benefit. And a lot of times those employers don't do monthly payments. They do like quarterly or annual payments, and they're sending them directly to the servicer. Or maybe you have a military benefit and the Department of Defense sends sort of a lump sum payment, or AmeriCorps or Peace Corps and other examples. Otherwise, there's really no benefit to you to paying yourself ahead. But if you're in that situation, they can count in that limited circumstance. Because of our limited time, I'm not gonna get into the more gory details about the repayment plans. I urge you to check out our website, freestudentloanadvice.org, for more information about how the income-driven plans work, as well as studentaid.gov. Studentaid.gov has a calculator called the Loan Simulator tool that will help you determine what the best plan is for you. Danger Will Robertson. That loan simulator currently has some messaging on there that in most cases is wrong, and it makes me nuts. It's telling a lot of people they have to consolidate to be eligible for a plan. Unless you have Fell or Perkins loans, that is never the case, ever. Consolidation, Parent Plus loans, you do have to consolidate to get access to income contingent repayment and IBR. But unless you have Parent Plus loans or Fell or Perkins, consolidation will never, ever change your repayment plan eligibility when it comes to the income-driven plans. So ignore that message. The other thing is the loan simulator tool has a glitch where it's telling people they're eligible for new IBR when they're not. If you have loans prior to July 1st, 2014, even if you have since consolidated those loans, you are not eligible for new IBR. You are only eligible as from the income-based repayment plans. As far as they're concerned, you're only eligible for old IBR. Consolidation does not change your eligibility from old IBR to new IBR. There are actually some servicer reps that are telling people that too, and I'm here to tell you that's wrong. It's written in the law. We talked about the PSLF help tool. Used to be you had to be with a particular servicer to progress towards PSLF. It was Fed Loan Servicing, and then it was Mohila. That's not the case anymore. It doesn't matter what servicer you're with. It's all centralized now with it looks like it's through the Department of Ed, but it's actually not Department of Ed employees that does the processing. It's a third-party vendor called Accenture that does all the processing for PSLF. But studentaid.gov is where you see all things PSLF now going forward. So I'm going to take another breath, Addison. We've covered all the eligibility and the application stuff for PSLF. We know what an eligible loan is. It's any federal direct loan as long as that loan's not in default. We know what eligible employment is. It's working at least 30 hours a week for any government employer, any 501c3, or in some cases, nonprofits that aren't 501c3s, as long as their primary reason for existence is one of the items on that list I showed you earlier. We know what an eligible payment is. It's any payment made on or after October of 07, while the loan was not in default or in a bankruptcy status. excuse me, while on either a 10-year standard plan or any of the income-driven plans. Now, before I get into the save stuff and NegReg, what do we got that I didn't do quite right or could do better, Addison?
We actually did have one interesting question that it's outside my experience, but I think you might be able to talk about it is federal unsubsidized health professions loans. Are those still available and will they circumvent the loan caps going into effect?
The HEAL loans are long gone. Uh, the health profession loans, I think they are still available. Um, as far as how that counts towards loan limits, we actually have to wait and see and get through NegReg. Um, I haven't seen a new health profession loan in a minute that's come across my radar. I'll have to double check on that. But if they do still exist, as far as the loan limits go, that's going to be a wait and see. Anything else, Addison?
No, lots of safe plan questions, of course.
Okay. All right. The SAVE plan was the Biden's administration attempt to create a payment plan that was more affordable, especially to lower income borrowers. In an unprecedented event, several Republican attorney generals sued the Department of Education, saying that the SAVE plan went beyond their authority under the law, that it was essentially too generous of a plan. And while the litigation is still ongoing, it seems that the courts are agreeing with that. Regardless of whether the courts agree with it or not, as part of the budget reconciliation bill, Congress gets rid of the SAVE plan anyway. But meanwhile, there at least originally were about 8 million borrowers in the SAVE plan forbearance limbo that they never asked for. If you're in the SAVE forbearance, these months do not count for PSLF, and paying during them will not make them count. If you're pursuing PSLF, you should not be paying a dime if you're in the SAVE forbearance. Yes, interest started accruing again on those loans on August 1st, but if you're pursuing PSLF, who cares? Because PSLF will end up forgiving that interest anyway. Now, you have a couple choices right now. You can either leave the SAVE forbearance and get on another income-driven plan, or you can ride out the SAVE forbearance for as long as it's available. We don't know how long that will be. I suspect there will be an actual official end date other than these sort of made-up placeholders the servicers have right now within the next year. That's pure speculation on my part. And if you choose to do that, you can do something that's called buyback. And I'm going to talk more about buyback in a second. One thing I want to mention, if you are trying to get on a different IDR plan for whatever reason, and your application hasn't been processed yet, there is still a big backlog. But if you submitted your application prior to April of 2025, it's recommended that you submit a new one. Or if what you checked on the application was you didn't check, you either checked the SAVE plan or you checked just pick a plan for me as long as it's the lowest one, you want to submit a new application because those are going to be rejected. But anybody who submitted prior to April of 2025, if it hasn't been processed yet, it's probably a good idea to submit a new application. Buyback. So buyback is a way to buy back or pay after the fact for months that didn't count towards PSLF, such as the SAVE forbearance. Now, you can only activate buyback once you have 120 months of certified eligible employment. But there is no sort of stale date to it. So you can buy back periods from 10 years ago if you're eligible to do that. You can't buy back any periods from prior to a consolidation. You can buy back most periods of deferment and forbearance. You cannot buy back periods of your grace period, or if your loans were in a so-called in-school status, which tends to be a Stafford loan before it goes into repayment for the first time. You can't buy back periods of default. So let's say you were in an in-school deferment or you were in a forbearance in 2012, and then you consolidated in 2014. You cannot buy back those periods of in-school deferment from 2012 because they occurred prior to consolidation. The way buyback works is you've certified 120 months of employment, including for the period that you're trying to buy back, and you submit the buyback request. And they look at what your lowest payment could have possibly been under an income-driven plan that you would have been eligible for at the time. They look at what your income was at the time. So as part of buyback, you have to submit proof of what your income was back then. And then they make an offer. Let's say they figure out, let's say you're submitting for buyback for 12 months of the save forbearance, and they determine that your payment during that time would have been $100 a month. They're going to send you an offer of $1,200, and you have to make it all at once. You don't, if you choose not to, it just means those 12 months won't count. You can't do half. It's sort of like an all or nothing thing. Now, one thing we do know is that they're not using the save calculation for the save months. They appear to be using the old repay plan calculation. So if you want to get a general idea of what your buyback amount might be for the save forbearance, if you figure out what your payment would be under either pay as you earn or new IBR, it's going to be right around the same as what repay would have been. Not exactly the same. Repay was a little bit different, but close enough, as they used to say for government work. Reconsideration is for months where you think you should have qualified, those months should have qualified, but didn't. Let's say they say your employer's not eligible and you think your employer should have been eligible, or if you were on an eligible plan and they say you weren't, those are reasons for reconsideration. You apply for reconsideration and buyback at studentaid.gov. All right, I know I only have a couple minutes left, so I really quickly want to go over PSLF negotiated rulemaking. Negotiated rulemaking is a process required by federal agencies when they want to change federal regulations. NEGREG cannot be retroactive, ever. NEGREG cannot be contrary to federal law, ever. So regulations can only be changed prospectively. The process requires the agency, in most cases, there are some emergency clearance items, to bring representatives of all the constituencies that might be affected by the new rule to the table and discuss the new rule and try to come up with a regulation that best serves all those constituencies. And then the public has an opportunity to comment on the draft rule and before the final rule comes out. Now, over the summer, there was a negotiated rulemaking around PSLF to implement an executive order that was issued by the White House back in March. That executive order would remove PSLF eligibility status from any employer that was considered to have engaged in, quote, substantial illegal purposes. Now, I was chosen as a negotiator representing consumers, consumer advocacy organizations, legal aid, and civil rights attorneys for that NEGREG. Spoiler alert, I was the only negotiator to vote no on the proposal. There were other negotiators that had significant concerns, but the Department of Ed really pressured the negotiators to allow them to come to consensus. And there was just too many things in this proposal that I strongly felt, and I'm not the only one that feels this way, were illegal. And even if not illegal, did not belong under the umbrella of the Secretary of Education, which is why I voted no. So the comment period for that draft just ended on September 17th, and I expect we'll see a final version of this on November 1st, and it would be, unless it's challenged and defeated in court, which, by the way, I 100% expect it to be challenged in court. I strongly suspect it will be defeated in court, because executive orders, just like regulations, cannot be contrary to federal law either. And the definition of an eligible employer, specifically for government employers and 501c3 organizations under the PSLF statute, does not leave a lot of wiggle room, or really any wiggle room. But anyway, if it does survive a court challenge, the earliest it would be effective would be for illegal activities that occur on or after July 1st, 2026. Now, they're defining substantial illegal purpose to mean they're confining it to only certain things. So, violation of immigration laws, federal immigration laws, terrorism, um, gender affirming care on minors, that is in violation of federal or state law, um, illegal discrimination, and protest activities. Now, I want to be super clear about this. Under this proposal, the activity has to be considered illegal under federal or state law. So if your state, if your hospital is performing gender affirming care on children, and that's allowed under either federal or state law, you shouldn't have anything to worry about. Now, remember, the federal statute under PSLF does not have any of that wiggle room. So that's why I don't think this will survive a court challenge. Here's the other piece of this, and this is one of the bigger reasons that I said no, is the way it's determined how an employer has engaged in substantial illegal activity. The first three ways sort of make sense. If a court decides, fair enough, that's a court's job, right? If there's a settlement where as part of the settlement, the employer admits it. They say, yep, I'm guilty. We engaged in this substantial illegal activity. Those are ways that the employer could lose PSLF eligibility going forward. The part that's very troubling is that the Secretary of Education is giving herself the authority to determine that there's a, quote, preponderance of the evidence that the employer has engaged in substantial legal activity around one of the areas that I described on the prior slide. And, to me, the Secretary of Education, there's already processes in place, such as a court, to determine whether something illegal happened. And these are my personal views. I don't think the Secretary of Education has a role in that. And there was significant concern around the table about whether this would be arbitrary, as far as who the Department of Education decided to determine had committed these, quote unquote, substantial illegal activities. In the draft regulation, the department says that they expect this to have a very small impact. They expect it'll affect less than 10 employers a year. Again, if this survives a court challenge, we'll have to see what that means. But I want to, before anybody outright panics about this, let me be very, very clear about even the worst case scenario with this proposal. Again, it's not retroactive. If you work for an employer that down the line is considered ineligible for this reason, all the months that you've already accrued will not go away, full stop. This only applies to illegal activities that occur on or after July 1st, 2026. So if your employer is committing terroristic acts today, as long as they don't do them on or after July 1st, 2026, they will not lose their PSLF eligibility under this proposal. If the department does sort of start sniffing around and say that employer is falling under this umbrella, you as a borrower that has already have certified employment for that employer will be warned that they are under investigation, for want of a better word. The employer will then have the ability to defend themselves. And if after they defend themselves, the department still says, no, we've deemed that you've committed this substantial legal activity, only at that moment going forward would the employer not be considered eligible. Anything during that investigation period would still be eligible for the employee's sake, and again, prior. And they will never take away existing months. Once the employer loses eligibility, they have the ability to get eligibility back by coming up with an action plan that's approved by the department. In fact, they can come up with an action plan during the investigation period, and if the department approves it, they never lose their eligibility at all. Again, personally, my own personal views, this is to me A, illegal, and B, an extreme overstep of this administration. I do think that courts will also see it that way, but if they don't, this is not necessarily a reason to panic at all. I'm seeing people taking money out of their 401ks to pay off their loans because they think their employer is going to get made ineligible. That's a terrible and panicked knee-jerk reaction. Remember, you're going to know well ahead of time if they're even at risk in the first place. And that's it. I know I've gone over by a couple minutes. I'm willing to hang out for another couple minutes if people have additional questions. And I know that Robert has a few more things to say, so I'm going to let him say those things, and then I'll take any last questions after that is done.
Thanks so much, Betsy. Thanks for packing it all in there. I know there's a lot to cover, and these are confusing times for those of us that are in the public service loan forgiveness program. I myself am someone who is in the SAVE forbearance process, and I'm navigating that as well with the help of folks like Betsy. So I would encourage everyone to reach out to TISLA. They are great at answering their questions in a comprehensive and coherent way quickly. Addison has done a wonderful job of answering more than or almost 50 questions during this session here. And if you do reach out to them, typically Betsy and her team are able to respond to you within 24 hours. So I would really encourage you to make use of this resource and the wealth of information and knowledge that they possess around this subject. It doesn't look like we have any pressing or other questions in the chat. So I want to thank Betsy and Addison for joining us. We really appreciate you sharing your knowledge with our community as we all try and navigate these confusing and uncertain times. I know there will be more to come on this subject. Count on Profits is dedicated to keeping you updated and informed. So please stick with us. And keep an eye on our website and our webpage for updates on our student debt program and upcoming webinars that focus on public service loan forgiveness. I also want to thank all the registrants for attending. You providing your questions into the Q&A are really helpful because I know so many of us have the same questions right now and are struggling to understand the nuances of some of the executive orders and how they affect our individual circumstances. And because our individual circumstances are all just that, individual circumstances, it is sometimes hard to get a clear question answered from a presentation like this. So once again, I would encourage you to reach out to Betsy and her team with your individual question about your specific circumstance, and they will be able to provide guidance. With that, we have reached our time today. So I want to thank you again for joining us. Thank our panelists again for all of their wonderful assistance, and wish everyone well. Take care of one another. Have a great afternoon. Goodbye.